things have settled down, so I think some familiar faces in the front row. Welcome everybody to this American Society of International Law panel on forced feeding. The first things I have to say are, one, that everybody should speak into the microphone. Can you hear me at the back?
Yes.
Okay. My colleagues who are going to may need to be reminded about that from time to time. And when we go to what the UN is pleased to call interactive dialogue, I will have to, I think, since I don't see any other microphones floating around, ask you to come up here and just pick up one of the microphones in front of our faces and say what you're going to say. I'll repeat that when the time comes. The other thing I have to say is that for those of you who are wanting CLE points or frequent flyer miles or whatever they're called, you have to scan your CLE frequent flyer card, especially when you leave. So when you leave here, make sure you scan whatever it is you have to scan. I'd like to thank the American Society of International Law for kindly inviting me to moderate this panel, which is on a topic of really profound legal, political, philosophical, and professional ethical issues. And the speakers will be able to take you across the range of issues in a way that I don't really feel a particular need to go over from the chair. But I guess it's going to range, as far as I can gather, from, on the one hand, those who feel that if a state deprives somebody of their freedom, they can't just sit back and let them lose their lives. And on the other hand, those who feel that a person, even deprived of liberty, has to be given the same fundamental autonomy and respect as any other person with human dignity, and not intervene against their will to save their lives unless there is any evidence of an impairment of will that could be relevant. That's going to be the range of legal and moral philosophical issues that I suspect we will be canvassing. We'll also be looking, I think, at both the interplay between international human rights law and international humanitarian law, the law of armed conflict, where there may also be some different takes, at least from the perspective of our panelists. I'm going to introduce them to you in the order in which they're going to speak. I will just be very brief in the description of them. Perhaps I ought to introduce myself. I'm sorry, my name is Nigel Rodley, a long-time member of the American Society of International Law. If anybody knows who would like a collection of the journal going back to 1960, I'd be very glad, because I can no longer accommodate them and I really don't want to see them pulped. And I'm current chair of the UN Human Rights Committee, former UN Special Rapporteur on Torture, and from the University of Essex, where I chair the Human Rights Centre. The first speaker is going to be Baher Azmi, the legal director for the Center for Constitutional Rights, a former colonel in the Israel Defense. Oh, I'm sorry. I'm jumping lines here. Who has been involved in the defense of a number of Guantanamo detainees. Sorry, Baher. I double took when I heard what I was saying. I sometimes try and listen to what I say, but I don't make a habit of it. And in fact, he's going to be the second speaker. The first speaker will be Walter Ruiz, who's now in private practice, formerly as a naval officer, and is appointed as defense attorney for captives before the Guantanamo Military Commission. And he's a defense attorney for Mustafa al-Hawsawi. Then there'll be Baher from the Center for Constitutional Rights, followed by my friend Stephen Xenakis, who is a medical expert with Physicians for Human Rights, What it says here, he spent nearly 3 months at Guantanamo and has interviewed multiple detainees. And there's other stuff he can tell you about himself maybe that will be relevant. It doesn't say here that in fact he's a former medical officer from the armed forces who rose to the rank of general before he retired. So forgive me if I add that to what I have here. Then we'll have Rachel Van Landringham, who's the Bruce R. Jacob Visiting Assistant Professor at Stetson University College of Law and former Chief of International Law of US CENTCOM, and she spent 4 years on detention issues and has been the first ever command liaison to the ICRC, if I've got it right. Then we'll finish the presentations with the one from Bill Lietzau on my right here, Assistant General Counsel at PAE. He tried to explain what PAE was to me, but PAE, and I'm not sure I got it, so he can tell you. Former Deputy Assistant Secretary of Defense for Detainee Policy between February 2010 and September 2013. Former Special Advisor to the General Counsel in the Office of the Secretary of Defense, and reportedly, am I allowed to say this?
Not sure. No, let's avoid that.
Okay, let's avoid that.
Oh, now everyone's going to... I'll mention it when I go.
Thanks, Bill. I'm sorry. I blame the organisers. So we're going to get going. They're going to be brief presentations, 5 minutes presentations. Then I will allow each of the panelists to ask a few questions of each other, and I won't necessarily exclude myself from that process. And then we'll open it up to the other participants, those of you who are on the receiving end, and I hope that there will be a lively discussion on these issues. So without further ado, I'm going to give the floor to Walter Ruiz, where is he? Starting at that end. Walter, that's it, take the mic and speak into it. We look forward to the presentation.
Thank you, Sir Nigel, and thank you for the invitation. They tell me I have 5 minutes, but I forgot to tell you that I'm looking at it as a lawyer's 5 minutes. So in any event, the question as has been posed and framed for me, and as I understand we're going to discuss today, is force feeding in response to hunger strike, degrading treatment, inhumane, does it amount to torture, is it in fact punishment? I will speak to that from the lens that I have, which is as a participant in Guantanamo defense. And I would say that from my perspective, it absolutely is degrading treatment, inhumane, and amounts to torture, and in many instances, punishment. And in order to understand why I say that, I think you have to have some understanding of Guantanamo Bay itself, because you need to understand the stimulus or the cause that gives rise to the manifestation of this hunger strike, peaceful means for protesting. And the reality about Guantanamo Bay is it is today's version of Devil's Island. Guantanamo Bay has become a place which is a dumping ground for lost souls, forgotten souls who are devoid of hope in many instances, and who have come to see their very physical existence as nothing but an existence rather than a life. The Guantanamo experiment was in essence conceived to circumvent some of our most basic protections and human rights in domestic law, constitutional law. Guantanamo is and has been and continues to remain a constitution-free zone. It also was geared towards avoiding the protections of the Geneva Conventions. It was supposed to be isolated, and it is isolated. It's supposed to isolate the individuals who were held in Guantanamo Bay. And it was conceived really out of fear. And it was a fear out of our own system of justice and the values that we cherish, and that our institutions couldn't handle these kinds of cases. These men have been held, in many instances, without trial for over 10 years. in most instances without any charges. In the very beginning and for a lengthy period of time without any contact whatsoever, without family members, no contact to lawyers, deprived of their rights to meet with consular representatives. To this day, Mr. al-Hassawi remains in a position where the United States government refuses to allow him to meet with representatives of Saudi Arabia. So this is the setting. This is the place that breeds hopelessness and despair. And out of that hopelessness and despair grew a cry from these men. Some of them, as you well know, that have been cleared for release for many, many years. And that was a thirst, in my view, for justice. Their cry and their expression was a thirst for justice. It was not a death wish. It was not an expression of the desire to die, but rather an expression of their desire to live, and to live a meaningful life, not just an existence. And in their desperation, they sought to obtain the meaningful life and some justice to their cause by engaging in a means of peaceful protest, which is what we refer to as the hunger strike. And that is exactly what they've done. That is exactly what they did. And what comes next, and what must never be forgotten, is the reaction. And the reaction, regardless of what the particular positions may say, and Guantanamo's mantra, because they come up with these mantras to stand for the values, is safe and transparent and humane treatment of individuals. And I would submit to you that while that sounds nice and it looks good on paper and it plays well on their website, it's not true in actuality. And actions must speak louder than words. And we know that they haven't in this case. And the reaction was fairly brutal. The reaction to this hunger strike and their peaceful means of an expression was essentially to deter. It was meant to deter any additional means of peaceful protest, such as hunger striking. It was meant to punish it. And it was made to make it so undesirable that nobody would want to go through those procedures again. And that is exactly what has happened. And I'm not sure some of you have seen the first-person accounts that have come out of Guantanamo Bay, but certainly we know that there are restraints, 6-point restraints, where people are virtually immobilized, unable to move whatsoever, while tubes are snaked through their nasal passages, scorching many times their nasal cavity as well as their esophageal passages. And they're fed multiple times, where body and fluid is pumped into their stomachs multiple times a day, in contravention to medical procedures and acceptable medical procedures, where tubes are removed multiple times, which prolong and increase the suffering of those types of forcible feedings. Men defecate on themselves. They're given laxatives and allowed to sit in their filth for moments at a time. And I would say that while we may be sitting here debating this, there is in fact no doubt that this constitutes degrading and inhumane treatment that amounts to torture. And I'm given an indication that my time is running out, so I'll wrap it up here real quickly. And I would simply say that the reality is far worse than perhaps what most people understand. And I think this is an important debate, and I look forward to having it today. Thank you very much.
Thank you very much, Walter. I'm sorry that beep sound from my iPhone, incidentally, wasn't that somebody was trying to call me. It was the timer going off after 5 minutes. It's the only way I can avoid being totally arbitrary. Thank you very much for the presentation. And the next speaker is going to be Baher Azmi from the Center for Constitutional Rights. The 5 minutes starts now, Baher. And the mic, sorry.
Of course. I lost 10 seconds. I'm the legal director of the Center for Constitutional Rights, which filed some of the first habeas petitions on behalf of Guantanamo detainees in 2002, resulting in the Supreme Court ruling in 2004, Rasul versus Bush, which authorized challenges to the legality of detentions in Guantanamo. And since that time, CCR has been coordinating the representation of hundreds of detainees. Currently, we represent directly 9 individual detainees, one of whom is, and nearly all of them participated in the mass hunger strike in the early months of 2003. And we currently still represent Tariq Ba'oda, a 34-year-old Yemeni detainee who's been cleared for release since 2009. And has been on a continuous long-term hunger strike since 2007, or what the military standard operating procedures now call, with a sort of Kafkaesque nod to the religion of the detainees, a long-term non-religious fast. And I think Dr. Xenakis will stress the ethical prohibitions on force feeding prisoners, particularly where they're not facing imminent death, appear fairly clear. The ICRC, various UN rapporteurs, the World Medical Association, the American Medical Association, bioethicists, human rights organizations have all regularly concluded that the force feeding of prisoners, including those at Guantanamo Bay, amounts to cruel, inhuman, and degrading treatment, which raises the prospect that the United States is in violation of its obligations under the Convention Against Torture and Common Article 3 of the Geneva Conventions. Not to mention President Obama's declaration in 2009 that detainees be treated, quote, humanely. So I don't see any ambiguity here, and in fact, a recent task force organized by the Institute on Medicine as a Profession, which is, I'm quoting here from a recent DC Circuit decision in the Shaker Amr case, quote, has issued a scathing report detailing the abuses of medical ethics in the government's treatment of detainees in Guantanamo, Afghanistan, and Iraq, concluding specifically that doctors who assist in the treatment of hunger striking detainees, and here quoting from the report, not just the opinion, have become agents of a coercive and counter-therapeutic procedure that for some detainees continued for months and years, resulting in untold pain, suffering, and tragedy for the detainees for whom they were medically responsible. But I want to focus to the extent that I can on a particular feature, because this question doesn't just arise in an ethical or abstract vacuum. In Guantanamo, I think there are 2 particular problems with the force-feeding regime, one related to motive and the other related to method. The first, as Walter suggested, the hunger strikers have no interest in dying. This is not a suicide mission. To the contrary, they are desperate to be returned home to their families and loved ones. They are engaging in a centuries-old form of protest, a protest over injustice of 13 years, up to 13 years of indefinite detention without prospect of release or trial. So it's a principled ethical stand and a peaceful protest involving the only thing they have control over, their ability to take food or not. And I think what's also important to remember is the force feeder in this case is not some sort of neutral jailer administering some duly adjudicated sentence by a valid tribunal. The force feeder here is not a morally neutral actor. The force feeder here, the Department of Defense, is the very cause of the injustice, the very cause of the protest that is motivating the detainees. And so rather than correct the injustice as an ethical principle, which this jailer has the power to do, i.e. release or try these detainees, sort of doubling down on one injustice, indefinite detention, with another, force feeding. Second, as Walter suggested, the method of force feeding Guantanamo is particularly difficult and such that it appears sort of gratuitously cruel. First, it doesn't happen at the point of imminent death. It's triggered under the regulations if a detainee misses 9 consecutive meals, or if they are 85% of their ideal body weight. It happens twice a day, not once a day, often after a forcible cell extraction, which is a sort of a violent and humiliating experience. After the 2003 hunger strike, humiliating general searches were instituted before the extractions for the feeding. As Walter suggests, they're strapped into a restraint chair, which is painful and humiliating. So what I think all this should demonstrate is that I'm not particularly convinced that the Department of Defense is acting out of a humanitarian or ethical instinct here, not out of the interests of the detainees. I think the Department of Defense recognizes the moral and political nature of this protest and is seeking to stifle it and to break the fast, not to save life. I think it's designed to preserve the legitimacy of Guantanamo, not necessarily the integrity of life. I think we see that, as Walter suggested, the crackdowns in 2003 and the imposition of solitary confinement for those who are engaged in hunger strike, again, and in 2003, a media blackout instituted by the Department of Defense so that it would not report on what was happening with the Guantanamo detainees. I have more to say. Actually, I have something to say on behalf of one of our clients, but I will leave that to my time later. Thank you.
Thank you, Bahar. You got the 10 seconds and a bit. And yes, just to indicate to the audience that I will hope just before we close to give each of the panelists up to 3 minutes to respond to the discussion. So that means 1, 2, 3, 6 of us, if I allow myself a few words too, something like 20 minutes before 4 o'clock when we have to finish, I will want to return the floor to the panelists. So the next speaker on my list is Steve Xenakis. Steve, you have the floor.
Well, thank you. It's a privilege to be here and appreciate it to hear and listen to the conversation. As Sir Nigel said, I'm a psychiatrist. I'm a retired Army Medical Corps officer, and had been a brigadier general and commanded a number of forces over the years, and have spent a good deal of time at Guantanamo since 2008. So I'd like to just share with you my thoughts of that experience, which is that the policy by the authorities at the JTF Gitmo to force feed detainees by nasogastric tube illustrates the gaps in understanding the mentality of the detainees, as Walter has said, appreciating the stresses imposed on them, and prerequisites for maintaining a constructive working relationship between guards and detainees. Furthermore, force feeding completely undermines the physician-patient relationship by destroying the trust that is essential for all clinical treatment, including medical issues unrelated to force feeding. It inappropriately engages physicians in the use of force against detainees. The World Medical Association has 2 ethical declarations: the Guidelines for Physicians Concerning Torture and Other Cruel, Inhuman, and Degrading Treatment, and 2, the Declaration of Malta on Hunger Strikers. The Declaration of Tokyo, the first, dates from 1975, states where a prisoner refuses nourishment and is considered by the physician as capable of forming an unimpaired and rational judgment concerning the consequences of such a voluntary refusal of nourishment, he or she shall not be fed artificially. The decision as to the capacity of the prisoner to form such a judgment should be confirmed by at least one other independent physician. The consequences of the refusal of nourishment shall be explained by the physician to the prisoner. The physician's role includes evaluating the detainee's medical and psychological condition, discussing consequences of fasting and options for taking some nutrients, monitoring the detainee's caloric intake, blood pressure, weight loss, and other medical consequences of fasting. The physician advises, counsels, listens, and assists the prisoner in clarifying goals, desires, and decisions. To perform this role, there must be a true doctor-patient relationship based on trust. And that, in fact, because of the conditions of confinement that Walter has talked about, is at this point highly unlikely, and in my view, just rarely, if ever, occurs. To establish the trust, the physician must be clinically independent of the authorities. They are not at Guantanamo. Doctors should not allow third parties to influence their clinical medical judgment, nor allow themselves to be pressured to breach ethical principles, such as intervening medically for non-clinical reasons. The prevailing opinion of experts is that hunger strikes are undertaken by persons who do not wish to die, as Osmer said, but are prepared to risk death in the hope that their demands are met. Case-by-case evaluation, however, remains critical. The WMA has determined that force feeding through the use of restraints is not only an ethical violation, but contravenes Article 3 of the Geneva Conventions. The ICRC has taken the same position. The American Medical Association position on force feeding is this: every competent patient has the right to refuse medical intervention, including life-sustaining interventions. The government asserts that detainees are still agents of al-Qaeda and continue to engage in asymmetrical warfare. Their tactics include participation in hunger strikes. The basis for this assertion is not disclosed for reasons of national security. I contend the government has engaged in subterfuge and distortion of the realities of conditions in the camps in propagating this assertion. It merely justifies inflicting harsh tactics in an attempt to break the will of the detainees and their disagreement with continued confinement. Medical personnel should refuse to participate in these tactics. Thank you, sir.
Thank you, Steve, and thanks for the immaculate keeping to time. I'm now going to turn to our last two speakers. I should point out, and I should have pointed that out before, in fact, the phantom person whom I described as a former colonel in the Israel Defense Forces is Pnina Sharvit Baruch, who was supposed to be part of this panel and would, as it were, have been part of the latter group of speakers who will be perhaps more explanatory, shall we say, of the forced feeding programs. Unfortunately, she had to pull out at short notice, so it's not for a lack of balance on the part of the organizers that you've had three speakers coming from one side and only two from the other, but those two, I'm sure you will soon see, will make up for in quality what may have been lost in quantity. So first of all, over to Rachel Van Landringham. You have the floor now. And Mike.
Thank you, Sir Nigel. Thank you, Aisel, Ms. Christina Cherna, Professor Larry Johnson from Columbia, my esteemed colleagues for this opportunity to participate in this very important discussion. And since the theme of this entire conference is the effectiveness of international law, I really do want to focus on what is the law, not just what is ethical in this area. My premise is rather straightforward, and it responds to the original query posed to the panel members, whether the force feeding of Guantanamo Bay detainees is torture, cruel, inhumane, or degrading treatment. And according to the law of armed conflict, international humanitarian law, which is the applicable law at Guantanamo, not only is force feeding not per se cruel, inhuman, or degrading treatment, I believe that the United States would actually be committing the most serious violation of Common Article 3 of the Geneva Conventions, analogous to a grave breach, if it failed to force feed a Guantanamo Bay detainee when medically necessary to save their lives. Why? The detaining authority in a non-international armed conflict, which all three branches of our government have found to exist, has a legal duty to preserve the life and the health of detainees in its care. Complementing this duty are the detainees' parallel rights under Common Article 3 and IHL customary international law to life and health. Critically, international humanitarian law on conflict, contains another important legal provision which is most applicable here. That is the absolute prohibition regarding non-renunciation of rights by detainees. prisoners of war, civilian security detainees, and the explicit terms of Common Article 3, those ordered to combat by reason of detention, i.e. the Guantanamo Bay detainees. What this principle of non-renunciation of rights means in this situation is that Mr. Hassan and the other Guantanamo Bay detainees are prohibited by international law from renouncing their right to life and health while in detention. And why does the LOAC include this non-renunciation principle for those in detention? Because, in the words of the inimitable Jean Pictet, the scrivener of the commentaries to the 1949 conventions, that the signatories to the Geneva Conventions recognize that, quote, it is difficult, if not impossible, to prove the existence of duress or pressure in a detention setting. Therefore, the Geneva Conventions prophylactically prohibit all renunciation of fundamental rights by detainees, including renunciations, again, of the right to health and life. And ultimately, a hunger strike that proceeds past a certain point is such an illegal renunciation of rights because, of course, a prolonged hunger strike without external medical intervention inevitably leads to death. Yet the voluntary nature of the detainee's so-called right to refuse nutrition all the way to and including the point that death will occur, a right articulated as a manifestation of the principle of human autonomy, in the words of the Malta Declaration, is the very linchpin to this right. It is also the indispensable element to the concomitant claim that by ignoring the voluntary autonomous choice of a competent detainee to refuse medical treatment, ignoring it by involuntarily through force feeding the starving detainee is inhumane. Yet international humanitarian law finds that it is legally impossible to accurately discern this critical element of voluntariness regarding a detainee's decision to starve to death. And hence, IHL instead prohibits that renunciation of that right to life. So this non-renunciation principle, coupled with the legal duty of the United States as a detaining power to preserve and protect the lives of those in detention, equal the finding that involuntary feeding or force feeding is not per se inhumane or otherwise violative of international law. It is actually required. So in conclusion, I'd like to use the same devil analogy, but instead mention, of course, the devil is in the details. While force feeding is not per se inhumane, the detaining power does have certain restrictions, and these restrictions were found by the European Court of Human Rights when it was determining whether the Swiss prisoner Rapaz could be force-fed just this past fall in November, and they found that it was not a violation of the European Convention of Human Rights and not cruel, inhumane, and degrading if these conditions are met. One, that there's a determination of medical necessity to save the life and health of a prisoner or detainee. Two, that appropriate procedural safeguards are in place to validate that decision so that it removes some of the concerns, the rightful concerns that Bahar just mentioned. That you have the detaining authority, the one that wanted them in detention in the first place, now saying that their medical necessity requires intervention. And three, that the interventions are conducted, the means, in a humane way. And even the International Criminal Tribunal for the former Yugoslavia found that force feeding can be conducted in a humane way, and they found that when they actually ordered the force feeding in 2006. Thank you, and I look forward to the discussion.
Thank you, Rachel, and thank you again for keeping so scrupulously to time. Bill, you've got a mic over there. So the last speaker on the panel is Bill Leetow. You have the floor.
Thank you. Thank you, Sir Nigel. Though I note that you just did assume that I was going to be on the other side of this question, which I don't think we had actually clarified that.
This is absolutely true, and you're if you want not to be, you don't have to be.
Thank you. I'm no longer in government, and so I'm free to say whatever I want. But I probably will be taking what's somewhat of another side, and I'll follow up with where Rachel left off with the legal discussion, because I think really she started getting into the ethical discussion, because let's face it, nobody drafts our laws to be unethical. Those kinds of ethical considerations are built into everything that we do with the law. And in fact, when we drafted the Geneva Conventions and we built in all these provisions that she was talking about of making sure that we're not making rash decisions about important issues in the midst of an armed conflict when people's thoughts aren't always as logical as they should be, we should avoid that. And there's all kinds of examples throughout the Geneva Conventions, not just the giving away of rights, but executing of penalties and all kinds of things that you have to wait until the end of hostilities, in some cases a year after, before you do something, so that we're not doing something rashly. And I think that absolutely plays into what I'll then focus on as the ethical piece, because I think Rachel covered the legal piece. Under domestic law, and I would argue under legal international law as well, there's really no issue here. Ethically, where are we? I don't want to get into a tit for tat on facts, but I think it is important that people in this room understand at least the rough outlines of DoD's policy. In 2006, the Department of Defense sent down a committee of medical experts to look at the Guantanamo detainees specifically, and to look at this issue of what our policy should be with respect to a hunger strike. We included the chair of the American Medical Association's Council on Ethics and Judicial Affairs, a physician member of Congress, a prominent Muslim physician, senior staff on the President's Council on Bioethics, a number of military medical professionals. And they came up with the policy that we have today, which is indeed designed around preserving life and health of detainees. It was known to be consistent with the law because it's a law that had been challenged many times in the Bureau of Prisons, which has essentially the same policies. It is not, of course, it does involve objective criteria like Bahar described, but the objective criteria are used by medical professionals to make their recommendations. They're not reflexive. If you miss this many meals, you're suddenly, have enteral feeding taking place. You look at the conditions of the detainee, whether they have hypertension, diabetes, some other medical condition that could be exacerbated by their particular fast situation. You look at their weight, you look at their physical status, and then you absolutely engage in all of the discussions that Dr. Xenakis listed. I think you were reading from the 75 Tokyo Protocol, and I think the 91's Malta Declaration, very similar recommendations as to what medical professionals should do in trying to explain to detainees where it hurts them and where it doesn't to be on this kind of fast. And that absolutely takes place every time there is a hunger striker, and it happens more and more frequently as you get to the point where it's possible or likely that there's going to be the nasogastric tube feeding. One thing to point out, and I did promise that I'll run out of time. I did promise I'd talk about what was on there, that it was a discussion of enemy combatant and my role in that. I'll only mention that. We don't have time to talk about it. But I think the IHL-HRL juxtaposition is important here, and that plays into that. It's not that important. This policy issue is a human rights matter and a human rights law matter. I think it comes out the same way, ethically. Nevertheless, under IHL, I would say it proceeds a fortiori from the argument in HRL. I already mentioned that basically what you've got is the sanctity of life on one hand and undermining someone's autonomy on the other hand. When you get down to that point where the doctor says we really need to do enteral feeding here, we're weighing in favor of preservation of life over personal autonomy. That discussion is dealt with quite a bit in the World Medical Association's declarations on this. Look back at the history. You're looking more than 20 years ago when people were being kept alive while being tortured, and they were being prevented from dying so that they could be tortured more. That's not the circumstances today. It's just not. And that's what led to some of those declarations. But right or wrong, that's a legitimate debate. What do you do with respect to that weighing of interest? I would say in a wartime scenario, you err on the side of preservation of life for all the reasons Pictet gave in the travaux to the Geneva Conventions. I'll note, for instance, that the Immigration and Customs Enforcement Agency also uses the exact same procedures. So this debate should not be about what do we do in Guantanamo. It should be about what does the U.S. government do with people detained in general. But whatever we do with people detained in general, we should do it even more so. We should be more careful in Guantanamo, where their authority to do their peaceful protests is exactly where it is. It's great. But at the same time, the chance of coercion, you heard the environment, the despondency that Commander Ruiz talked about. Yes, That's where they are. And we need to be especially careful that they might not be mentally competent to make the right decisions about their own life.
Thank you, and again, thank you for keeping to time. As I said, I'll have a little bit of interchange in the panel first before opening it up. And what I'm proposing...
That's me. I wanted to make sure he didn't go over.
Touché. Set it at 10, will you? I'll throw a question out in each direction, and then also invite the panelists if they want to ask each other any brief questions, and I mean brief questions, not long responses to what they've heard, but a little bit of cross dialogue here would be useful. And so let me start with those who are challenging either the principle of forced feeding or forced feeding as it applies in Guantanamo. And may I say that there are three threads to this discussion, and it may be useful for us at least to keep them in our heads as part of the complications. One is forced feeding ever justified against a conscious political protest of hunger striking? Is it justified in the way it's being done in Guantanamo? Is it justified in Guantanamo and the whole context of detention in Guantanamo? All those issues are in play in this discussion. The question we were asked is just the abstract one. The first one I mentioned is force feeding in response to hunger strikes a violation of the prohibition of torture and cruel, inhuman, or degrading treatment. So when all of us address the issues, it would be good if we could clarify what of those three dimensions we are addressing. And so my question, first of all, to those who are challenging the principle of forced feeding or the principle of forced feeding as it's applied in Guantanamo is how you deal with the allegation, assuming there may be some substance to it, and I must say I have come across in my own work corporate decisions on behalf of prisoners whereby they feel obliged to stick to some kind of corporate ethos rather than exercise their own independent individual judgment if they feel able to at all. How do we avoid that issue being the one that determines a person's decision to hunger strike rather than a genuine autonomous reason of the sort that one would normally perhaps be thinking of protecting? Bill? Sorry, Walter, do you want to start? Go ahead.
I think I understand. You're asking basically how to build a safeguard to determine if a person's really making a decision based on their own autonomy versus driven by despair or hopelessness. I can give you
straight into the mic.
I can give you a practical world example of how we tried to do that in Mr. Al-Hassawi's case very recently, as we asked the one military judge who is sitting in Guantanamo Bay. We filed a motion to preclude the use of force feeding on Mr. Al-Hassawi, or in the alternative, if it was determined that he was on a hunger strike type protocol, that the attorneys would be given notice of that protocol and that the protocol had been established. And the reason for that was that we felt that over the course of time we had managed to build a relationship of trust and respect with Mr. Al-Hassawi. And one of the things General Sanakis can speak to is, and he did speak to, was the relationship of trust between patient and doctor. And that hasn't always been the case in Guantanamo Bay. So when we addressed this issue in court, we told the judge that it would be an additional safeguard where a person who has an established relationship with some of these men, the ones that have legal representation, could actually engage them in a dialogue. As advocates, we have their interest at stake. That's the person we represent. So it was our position that we would be in the best position to assert and affirm that, in fact, this was somebody who was exercising that judgment in a manner that was consistent with rational judgment and wasn't being improperly influenced by, let's say, the popular opinion or peer pressure for lack of a better term. And the reality is that they are being influenced, and that influence comes from the oppressive conditions that they see every day. But our position was rejected, and it was essentially rejected because Mr. Al-Hassawi had not actually been force-fed, which obviously would have defeated the purpose of filing a motion asking them to provide us with notice and an opportunity to engage the person we represent and whose interests are at stake from doing that. The standard operating procedures in Guantanamo Bay also include provisions that a physician is not ultimately the decision maker. And so the physician actually just makes a recommendation to the commander of the base. The commander of the base then has to basically ask for permission from the commander of Southern Command, who is based in Florida. So you're not seeing a situation where there is this imminence of somebody wanting to be force-fed or being force-fed. In fact, the very standard operating procedure indicates that the government built in their own internal check boxes and procedures before they did that, but they were not allowed to do that to representatives and to the attorneys who be in a position to do that, having established a relationship, in my case, over 4 years with somebody who has come to gather a measure of trust, even with somebody who represented him for many, many years in uniform and was a representative of the government who had treated him less than within the standards of international humanitarian law and in contravention of prohibitions against torture and degrading treatment to begin with. So I think that's one way, Sir Nigel. I think one way is to provide the opportunity for representatives of these men to have meaningful conversations with them, to be on notice, to meet with the physicians. We are not allowed to know who the doctors are. We are not allowed to meet with medical personnel. Now, I've practiced in just about every jurisdiction in the United States, regular military court-martials, state courts, and federal courts. I can tell you it's the first time that I've ever been unable to meet with a physician to discuss a condition that was of a concern about my client. In fact, it's almost it's offensive, to tell you the truth, because the physicians actually wear fake names, and they'll use fake names that are like Freddy Krueger, and they think that this is something that is comical. So do the staff judge advocates. They're not allowed to wear their names, so they wear pseudonyms or AKAs. And for us just to have the opportunity to speak to a doctor, we have to go through an attorney. We have to submit a request to the doctor. We just recently did it in Mr. Al-Hassawi's case, where we were asking for a particular procedure. And the fact of the matter is that we were not able to have access to the medical personnel. In the context of force feeding, I think in order to determine if in fact they are acting on their own volition, it would be very helpful to have access to physicians and to be able to speak to them and to have a dialogue, but that is prohibited in Guantanamo Bay.
Thank you very much for that, Walter. I will give Bahar a chance, but to add anything to what Walter has already said, rather than just to reinforce what he said.
Well, just very, very quickly, I mean, I think there should be a presumption that these individuals are acting rationally and autonomously in protest of their conditions. After all, it certainly maps to the reality of what the world perceives about injustice in Guantanamo. And that presumption, as Walter suggests, can be tested if it's in question through the use of advocates or judges. And in terms of the sort of cooperation or group nature of the hunger strike, particularly the mass hunger strike in 2013, again, the presumption for me there is this is an act of fellowship and strength driven by autonomous choices by individuals who, like-minded individuals who see solidarity in their unjust detention. And not everyone participated, although a majority did, because of a moment of opportunity, a political opportunity